virtual training of the series. We would, just a couple things before we get started. Please keep your microphones muted and your video off. We just don't want any distractions for our presenter and or anybody else. If you have questions, please type them in the chat box and I will be relaying them to our presenter go along. So to get started today, we have Kirsten with the Department of Labor, and her presentation is on fair housing.
Thanks, Kylie. So I'm Kirsten Small with the Department of Labor. I'm a compliance investigator here. I've been with the department for 5 years now. I've done a couple hundred investigations over the time that I've been here. Previously, I've worked in the transportation department or transportation industry, and I also have a degree in social work. So I've kind of worked with various types of discrimination and investigation for quite some time. Today, we're going to kind of go over a little bit about the department itself, explain a little bit of what our department does, what we handle. Obviously, today we're going to talk a lot about fair housing, but the department does handle a variety of different issues as well. And so we'll kind of discuss those a little bit. We'll explain what exactly housing discrimination is. We'll talk about what the fair housing laws are that we handle, what kind of guides our work at the department. We'll go over some of the statistics and facts, some of the information as far as common issues, so things that we see frequently within the department related to fair housing issues. And then lastly, we'll go over a little bit of advice going forward so that hopefully you don't necessarily have to deal with issues with our department, or if you do have a claim filed against you, at least you'll kind of know what to expect and how to respond to those complaints. So first and foremost, we'll go over a little bit about what the department does. Prior to me working at the department, I will be completely honest, I had no idea what the department did, what they handled. Basically, there's three major divisions that the department handles. The wage and hour division, which is for things like unpaid wages, maybe unpaid vacation time, unauthorized deductions. We handle youth employment. So any employee that's 14 or 15 in the state, we handle the laws that pertain to how they can work, and then also the permitting and licensing for them. We handle independent contractor verifications, as well as a few other things related to the wage and hour division. The human rights division, that's where the fair housing falls under. That's the discrimination side of things. So we handle various types of discrimination, but anything that would be discrimination related falls under the human rights division. And then lastly, education and awareness. That's the third pillar of what we do. And that's things like this. We do presentations, we do booths, we do public outreach, basically trying to inform the communities of what our department does and what laws that we have. So again, hopefully individuals will follow the laws and be at least more aware of what they are. As far as the laws that fall under the human rights side of things, so there's obviously a number of laws that handle, whether it's the Century Code or the Administrative Code for the Wage and Hour Division, but for specifically the Human Rights Division, there's 4 different main laws that, or areas of the law that we handle. The Human Rights Act, that would be mostly related to employment discrimination. There's also discrimination for public service and public accommodation, which we'll talk a little bit more in a second here. The North Dakota Housing Discrimination Act, that's where the fair housing laws fall. That handles discrimination specifically in housing within the state of North Dakota. And then the last 2 are much smaller sections of the law that we handle. The whistleblower law, that would be pertaining mostly in employment. And that's if an employee, for example, reports some sort of issue to OSHA, and then as a result, the employer takes some sort of retaliatory act against them. So maybe they demote them, they fire them, they issue them a write-up because of the fact that they had filed this OSHA complaint. They can file a complaint under the whistleblower law. And then lastly, the North Dakota Public Employee Relations Act, that is specifically for only certain types of public employees, and it's very specific on basically if an employee makes, a public employee makes a complaint to their head, their department head or their agency head, and that, or the state's attorney, very specific situations. And it's similar to the Whistleblower Act, but again, it's only for public employees. So when we talk about how many contacts per year, this is based on our last biennium. So we're kind of in the middle right now of a biennium. Our new biennium, or this current biennium, will be up at the end of July of 2021. So we still have some time left on this biennium. So instead of just giving a half piece of the statistics, we kind of just went to the last biennium. And we've had about almost 8,000 public contacts, and that's anybody who contacts our department. So whether that's through telephone calls, it could be emails, it could be somebody actually physically walking into our department, any sort of public contact that we have that's considered wage and hour related. So that it might be anything related to the wage and hour laws. We consider that a public contact. So again, about 8,000 of those. We had, again, in the last biennium, about 771 claims filed and 847 claims closed. Basically, back in 2015, when the oil boom was kind of on the backside of things, we had a huge influx of claims still pending. So we had basically a backlog of hundreds and hundreds of claims. So even though we've closed more claims than were actually filed, it was basically still kind of digging out of that hole. It should be leveling off through this next biennium, pending any other major influxes of claims, but that basically the oil boom caused us to have a huge backlog of both wage and hour complaints as well as human rights complaints. So when we talk about the human rights, I kind of went over this when we talked about the laws a little bit, but specifically what human rights is, again, it's the discrimination side of things, and that's employment discrimination. So an employer discriminating against an employee, public service and public accommodation. Public service would be something like going to the DMV or having the water service. It's a service it's not necessarily like an accommodation, which would be like Walmart or something where you go to get a good or a service for some sort of fee. Public service is more of a public or governmental type of agency. And so we handle discrimination in those areas. So again, if an individual went into, let's say, a gas station and they believe that the employee discriminated against them, they can file a complaint with our department in order for us to look into it. The next one is credit transaction discrimination. We don't oftentimes see a lot of this, just as far as people filing. Oftentimes they may file under a public service or public accommodation, but it may somewhat be related to credit transactions. Credit transactions would be if you went into a bank and went to get a loan and you believe that the way they went about either approving you or declining you from having that loan was discriminatory, then you could file a complaint on behalf of the credit transaction discrimination. And then lastly is what we'll talk about mostly today, which is housing discrimination, which obviously is discrimination in the realm of housing. As far as the public contacts, again, the wage and hour was about 8,000 public contacts. As you can see, substantially less for the human rights side of things, about 2,500, little more than 2,500 public contacts for the human rights issues, 426 claims filed, 487 claims closed. Again, it was around that 700 for the wage and hour. Oftentimes, not as many people necessarily either know that our department exists or they just don't necessarily feel that they want to file because, you know, they can't believe that discrimination happened to them, or they don't believe that anything will be done about it. So they might not necessarily contact our department. But just as a whole, we see substantially less human rights issues or complaints than we do of the wage and hour side of things. So we'll go through what exactly the definition of housing discrimination is, and then we'll kind of stop for a minute and go through any questions. So what is housing discrimination? Obviously, it seems pretty cut and dry. The definition really is treating someone differently in the sale or rental of housing because of a person's membership in a protected category. Oftentimes under the law, even people who don't mean to discriminate are responsible for discrimination. So even if you intended for a good thing to happen, you can still be found to have been acting illegally. Basically, the laws themselves were created in particular to prevent discrimination in housing. That's what the entire purpose of fair housing laws, why they were established federally and on the state level, is to kind of level that playing field and ensure that all individuals were being treated fairly and equally in their housing. So whether that would be sort of the rental, sale, or any of those housing transactions. So when we talk about housing discrimination, so it's discrimination based on a protected category. And so the protected categories themselves, it's not just anything and everything. The specific Fair Housing Act, the federal side of things, that protected categories is race, color, religion, national origin, sex, familial status, and disability. Familial status, that is the presence of an individual that's under 18, an individual that's pregnant, or obtaining the custody of a minor. And then we also have some state-only protected categories. So these, although they're not on the federal side of things, they still can be filed on because they are under our state law. And that is the receipt of public assistance, marital status, age, which is 40 and over, and then certain victims of domestic violence. So those are the protected categories. Basically, when somebody files, we evaluate whether or not the individual is alleging some sort of discrimination based on one of these protected categories. So specifically, that's what we're looking for when we're looking at whether or not they've been discriminated against under what we have jurisdiction on in the law. If it falls outside of those things, we may not have jurisdiction. The individual may be able to try to pursue the issue through court, for example, or whatever the case may be. But these are the only areas legally that we have any standing or jurisdiction to investigate. So the specific fair housing laws themselves, the first one is the Fair Housing Act of 1968. That's a federal law. It's the Civil Rights Act. It's commonly known as the Fair Housing Act. Basically, it was established approximately 51 years ago now, and it was basically established to, again, kind of level that playing field to make sure that there wasn't discrimination in housing, to again make sure that all individuals were being treated equally, not on the basis of any of those protected categories. And then we also have a state law, which is the North Dakota Housing Discrimination Act of 1999. That is, again, the state only, that has the state only protections, but it also has laws that are what we call substantially equivalent to the federal law, or about the same as the federal law. We do have a work sharing agreement with HUD. So we basically work with the Housing and Urban Development, and instead of having two separate agencies come in and do one investigation, we basically can investigate any sort of complaint on their behalf and our behalf, or vice versa. So they can come in and investigate, and then we may be able to adopt the findings depending on their investigation. Basically, it's we have to have certain things in place. So we have to, again, have substantially equivalent laws, which our law can't be significantly different than the federal law. Basically, whatever our law states is completely contrary to what the federal law states. We can't have that. We have to have fairly similar laws. And then also, we have to have the opportunity to be audited, basically, by HUD. They come in, they basically review any files that they request as far as any housing investigations, just to make sure that everything on their guidelines is being followed. And that's kind of what our dual work sharing agreement is. And again, it just prevents from both parties having to have two investigations at the same time for the same issue. It saves both parties time, kind of frustration. So for the time being, been for quite a while. We've had this work sharing agreement, and I foresee it happening for the future without, anything coming up and changing that. So before we go into any of the exemptions of law, are there any questions so far?
Not yet.
Okay, perfect. I'm either going too fast or people don't have questions.
Oh, there's one getting typed right now.
Okay, oh, wait 1 second.
This is Jennifer. Is there any, can you hear me?
Yep.
I'm just going to ask my question rather than typing it, if that's okay.
That works for me.
We actually have a question regarding mobile home parks. Are they obligated under fair housing? And this is kind of, maybe I should wait for this question. So this is regarding a reasonable modification request. Is that something I should wait for? Can you touch on that?
Possibly. It really is, they can. So they can be subject to the fair housing laws. It really just depends on the specifics of it, of what kind of facility it is, because there are exemptions from the law, pretty specific ones, but depending on how, if they're like rented out or if it's owned, they can be subject to any of the fair housing laws. It really just depends on a very individualized basis. So I couldn't say 100% yes or no, but it's quite possible that they likely do fall under the fair housing laws. Just, I can't say for certain yes or no type of thing.
So one of my questions is related to if a tenant who is renting a mobile home in a mobile home park requests a ramp to be installed because they need wheelchair accessibility. My understanding is that they are not required to remove that if they vacate the property. Is that correct? That they wouldn't be required to return that modification, or would they?
So modifications, specifically the cost itself lies on the individual. As far as the removal piece of it, I honestly would have to look a little bit more on it, specifically for something like a ramp, because sometimes it's things like grab bars, things like the things that wouldn't necessarily, in a mobile home park, truly the entirety of the facility, the home, could be moved. And so I don't know if that affects it any, but generally speaking, a modification doesn't necessarily have to be removed, or they don't have to take it with them, but I don't know specifically related to a mobile home.
Okay.
So I could certainly look into it, and I'll at least try to get you a best answer, but I don't know off the top of my head.
Maybe I'll email you my question on the side.
That would be great. Yep, that would be great.
Thank you so much.
I didn't provide a great answer, but we'll see, we'll find you a good answer.
One more question.
Sure.
Is sexual orientation not a protected class?
It actually, so ironically, I didn't have it in the presentation because it is, so this just went through July 15th, the ruling came down, and it's kind of in limbo right now for the Housing Discrimination Act specifically, because there is nothing on the state laws that pertain to sexual orientation. Obviously, the federal ruling was more specifically related to employment discrimination. And so I know that was something that was being discussed between our commissioner and our human rights director to decide whether or not, based on the language of the Housing Discrimination Act, whether or not it fell under that. And I'm not entirely sure they had a firm answer yet, but I can check with them and email that out as well. Because like I said, it is very new, and they were kind of trying to establish whether or not, based on the language in the Housing Discrimination Act, whether or not it could fall under it based on that language that's in there. So I'd have to double check it, but I can certainly email that out to whoever asked that question.
That is it for right now.
Okay. So we'll move into the exemptions from the law. So there are certain sales or rentals that are exempt, certain religious organizations that are exempt, private clubs, and then housing for elderly. Specifically, when it talks about the certain sales or rentals that are exempt, this is what we consider the Mrs. Murphy law, and that means that it's 4 or fewer rental units and the owner lives in one of the units. This one thing that we see not oftentimes, but occasionally, is if the Mrs. Murphy exemption is stated or alleged in any sort of discrimination complaint, we do look into it. And we would, I mean, obviously we would look to see specifically whether or not the owner actually lives in the unit. And sometimes what that can come down to is who the actual owner on the paperwork is. So even though the person who does all the managing is the one who really handles everything and by all means is pretty much like the owner, but actually on the paperwork, the actual owner is not living in those units, they may not fall under that Mrs. Murphy's exemption. So when looking at Mrs. Murphy's exemption, like I said, it's 4 or fewer units and the owner has to live in one of those units. Religious exemption, that is specifically for basically any sort of religious organization or on the basis of religion. But one of the nuances is that they still cannot discriminate based on race, color, or national origin. So although it basically allows for discrimination in some ways, it allows for some of those exemptions, it still does not exempt the race, color, or national origin sections of the law. Private clubs, very similar. Basically, they can have like a membership only or a private club, but again, cannot discriminate based on that race, color, or national origin. Those are those 3 nuances. And then lastly, the elderly exemption. That is specifically for familial status and age for developments. For example, 55 plus communities, things like that, there is the exemption from the law regarding those. So we'll move into the statistics and facts a little bit, and then we'll kind of take a pause again if there are any questions. So for the last biennium, like I said, we are in the middle of a biennium right now. So this would be for basically the numbers that were ending in July of 2019 or the very end of June 30th of 2019. When we look at it, we had 58 total claims. Of those, 34 of them were conciliated. 15 of them we found no reasonable cause, which means we found that no violation of the law occurred. One of them we did determine a violation of the law occurred or that there was reasonable cause to issue a charge. One was dismissed. 5 of them were referred to HUD because again, we have that partnership. So some cases may by request or just on the basis or the request of HUD, they can be referred to HUD to do the investigation. And then 2 were withdrawn with resolution. When we look at the actual kind of breakdown of these cases, so again, we had 58 claims. 43 of those were disability, 6 retaliation, 4 public assistance, 4 familial status, 3 national origin, 3 were color, 1 was age, 2 sex, and 4 race. As you can see just from the breakdown of these numbers, that's significantly more than 58 cases. And that reason for that is oftentimes cases can be filed on multiple bases. A great example is a lot of cases may be filed on something like disability for maybe a reasonable accommodation and retaliation because they believe that they were retaliated against for requesting that reasonable accommodation. Or it may be filed on the basis of race and color and maybe even national origin as well. So it oftentimes can have multiple bases. One thing to note is of these cases, so of the 43 disability cases that we had, 32 of them were for reasonable accommodation. So by far, with relation to disability, we see a lot of cases that come through that are related to reasonable accommodations. We do see reasonable modifications as well, but a lot of what we see is a lot of reasonable accommodation requests, and they believe that those were denied in violation of the law. As far as for that last biennium, the average days to close each case, just what our general average was 63 days from the time that they were opened. Generally speaking, when it comes to requirements by our law as well as HUD, we aim and strive to close a case within 100 days. If we do not close a case within 100 days, we have to reach out to both parties and provide a formal written reason as to why we were unable to close the case in that certain amount of time. So that, you know, having it at that 63 days is significantly less than the 100 days, but that does mean we still have cases. You know, we can have cases that close within a couple days, and we can have cases that close within a year or two. So it's kind of all over the board, but again, that requirement or that expectation is that 100 days, and if it doesn't get completed within that time, we just have to provide a formal written reasoning to both parties of why the case was not able to be resolved within that 100 days. So before we go into the complaint process, do we have any other questions?
Is there a time frame in which a person must file a complaint or claim from when the issue occurred?
Great question. We're actually getting into that next, but I can give you the answer anyway. It is 1 year by statute. It's not read as 365 days. It is read specifically as 1 year from the last date of harm. So basically they have from that last date of harm till the time that we actually receive a filed charge, it has to be done within 1 year.
That's it.
Perfect. So we'll kind of explain a little bit of what the complaints process is. Hopefully a lot of people don't have to necessarily deal a lot with us. When it comes to amount of cases, like I said, we had about that 400 mark for cases that were filed just for human rights complaints. And as you see, 58 of them were housing. So we don't have a significant amount of housing cases filed each year. But for that reason, a lot of people don't necessarily know what to expect if a housing case is filed against them. They're not sure how they're supposed to react. They're not sure how they're supposed to handle it. So I'll kind of walk through a little bit of what the complaint process is, just to explain and help everyone understand a little bit of what that process is. So any citizen within the state can file a housing complaint if they believe that they've been discriminated against. And one thing to note here, so obviously it says any citizen can file. It can be anyone. You know, I'm sure if you're in the housing realm, you've heard of things like testers. So people that will contact a landlord and basically ask them certain questions or see if they get some sort of discriminatory answer. Basically kind of a check-in to see if the landlord's doing the right thing. Not always really it's yours, it can be any individual. Additionally, it can also be people filing on the behalf of others. So it could be, let's say, in the case of something like familial status, it could be something related to an individual in the household who is an individual with a disability, maybe a minor who is an individual with a disability, and the parent is filing on behalf of the situation for that minor. Or it could be, in the case again of disability, it could be the individual that's not necessarily living in the house, but they're assisting because the individual is maybe incapacitated or, you know, doesn't have the mental capabilities to file the complaint on their own. They may assist in that filing as well. So they can file on the behalf of others. And then again, they can also be things like a testing agency or something of the sort. Like we just said, the statute of limitations is 1 year from the date of the alleged discriminatory practice. So basically 1 year from the last date of harm. When we look at a complaint, so we received a complaint, one thing that we're looking for is what we call a nexus or connection between what the alleged action was and what the protected category is. So basically the individual that's filing has to explain why they believe or what the connection is between what their protected category is and what actually occurred. So for example, if an individual says, I believe that I was evicted, and you said, okay, why do you think that that happened? And they said, well, I don't know, but looking at your protected categories, I am in this one. You know, they have to make some sort of connection, or at least an explanation of what that connection is, as opposed to just picking a category just because they potentially occupy that category. The formal complaint will be drafted, reviewed by the complainant, and signed. So basically, when we receive the intake paperwork or that initial complaint, we work with the complainant, again, to see what that connection is, what the nexus is, and whether or not we have standing. So we look at the timeline. With what is it within that statute of limitations timeframe? Can we even look into and address these issues? We look at whether or not the issue is within anything we handle. Is it something that they're actually alleging discrimination related to housing, or you know, is it something completely unrelated that we don't actually have jurisdiction over? And so we look at those things, we kind of evaluate those things, and then we draft a formal complaint. When we draft that formal complaint, basically it's kind of a breakdown or a bit of a shorter explanation, because generally speaking, when we get some of these intakes, it might not necessarily be in a neat, tidy format of explaining exactly what the issues are. So our hope is by kind of paraphrasing and explaining it a little more closely, the respondent will be able to respond better and understand what the allegations are. So we complete the charge itself, or the complaint, and then we send it to the complainant. They review it. They look to make sure that everything's accurate and correct, and it's exactly what they are alleging. And then they can sign it, and we'll formally open the complaint. Once we open the complaint, then we send it to the respondent for a response. So basically, we're looking for formal response to the allegations. We request certain things related to it, some comparative information, or maybe copies of policies. We're looking a lot for documentation. So if it's an individual, let's say they're alleging some sort of eviction process, anything that would be in support of the respondent's position or explaining what exactly occurred, that's what we would be looking for. So if there were any sort of written notices, any written policies that the individual signed off on, any like late notices, things like that, any evidence is what we would be looking for. And then also a formal written response to the allegations. So basically the respondent's side of things. A lot of times we do receive these are completed and drafted by attorneys. So a lot of times the respondent will have an attorney provide the response to us, but not in all cases. You know, if you do have an attorney to provide a response, it's ideal to get an attorney that handles specifically housing issues or has potentially handled any housing discrimination within the state before. Generally speaking, they can at least, they know a little bit more of what we might be looking for, of explanation of the basis of what happened, and kind of the legal background to it. So once we receive the response from the employer or from the landlord, then we have it assigned to an investigator to actually be investigated. With housing cases, that's generally the person that drafted the complaint. So basically, once the intake comes in and we draft that formal complaint, that individual will stay with that complaint all the way through until it's closed. So you're not working with a bunch of different people. They kind of know the situation. They know the background on both sides. So they kind of understand you're not having to re-explain everything brand new to a new investigator. And then during the investigation, like I said, we'll be reviewing all of the documents from both sides. We'll be looking at policies, notices, files, the response itself, do any sort of interviews. So that could be interviewing different witnesses, other tenants, the respondents, the complainant themselves, and then we also review a timeline of the events that occurred. When we're looking at what the role of the department investigator is, we are a neutral third party in all of these. And so when we look at a complaint, excuse me, the investigator themselves, we conduct a fair, impartial, and thorough investigation into the facts and circumstances. We are not on the claimant's behalf. We're not on the respondent's behalf. We are truly a neutral third party. All we do is take the facts and the evidence, compare it to the law to see whether or not a violation of the law occurred. Generally speaking, when we have any complaint, whether it's for wage and hour or a discrimination complaint, a human rights complaint, 100% of the time, some party is going to be upset with the finding. So whether or not it's the respondent or the complainant, someone usually is upset with the fact that we either found cause or we did not find cause. So when it comes to providing responses, I know it can be very emotional for both parties. It can be very difficult for the complainant to kind of relive what they believe was discrimination or what they, what incidents occurred that they believe that they were wronged. And same with the respondent. The respondent can feel very slighted that the complaint occurred and that they don't believe that there is any sort of cause or any violation of the law occurred. And it can get very emotional. We completely understand that. But again, we truly are the neutral third party. We're not on either behalf. So when we're asking questions or we're asking for additional information, it's truly just to come to some sort of conclusion. Again, whether or not that's in either party's favor, that's kind of an individual perspective, because again, at times somebody's usually upset with the finding that we've made. But again, all our job is to collect the facts and the evidence and answer whether or not we believe a violation of the law occurred. So we talked a little bit earlier about conciliation. We had a substantial amount of the cases that were resolved through conciliation. What is conciliation itself? So basically, with us having the Fair Housing Act as well as that federal partner side of things with HUD, they very highly encourage trying to resolve the issues. And it really can benefit both parties. Basically, it can be the conferencing negotiations, trying to come to some sort of resolution prior to an actual decision being made or the completion of the investigation being made. One of the things is, it can benefit both parties because it can be very time consuming. Again, we do try to resolve these issues in a timely fashion, but trying to find all of the documentation, witnessing all the different parties, it can be talking to managers and supervisors or other tenants, things like that. It can be very time consuming for all of the parties involved. And it can be very difficult. Again, it's very emotional. A lot of these processes, it can be upsetting to both parties. And so trying to kind of resolve it through those informal negotiations can at least decide some of that and provide some sort of relief to both parties. It's usually, we say, not any parties happy with mediation or what the conclusion of a conciliation is, but it's what both parties can at least walk away feeling that they feel at least satisfied with the result. It is a voluntary process. Basically, both parties can choose to go forward with it or not. And so it is voluntary in that way. It's between the aggrieved person or persons and the respondent, and then the department just acts as that middle party. We act as the conciliator. When we talk about it's confidential, basically any record within the state is subject to open records, but when it comes to any sort of conciliation agreement, if both parties agree to basically it being confidential in some way, and the department as a whole feels that maintaining the confidential piece of it won't impact the fair housing laws at all, it can remain confidential, but as a whole, it doesn't necessarily come to that, but it can be at least discussed in trying to be confidential, even though records laws. Either party has a right to representation during these proceedings, whether that's an attorney or just another party. It could be, somebody else, the respondent has maybe somebody who just is acting as a representative. Same with the complainant. It could be a family friend. It could be somebody that they do act as representation during the process. And then the agreements themselves, they are binding. And so basically whatever comes as a conclusion to these conciliations, it can be a binding agreement. And again, it's just to try to resolve the issue prior to going through the entire investigation. It can be a point throughout the process. So it can be from the time that a complaint is filed all the way through, when we issue a charge. So the conciliation can be at any point during the process. And again, it doesn't always seem it to both parties, but it certainly can be beneficial to both parties because of the fact that, again, it can be very stressful handling one of these investigations. There's usually a lot of questions. There's a lot of going back on what tends to be very emotional times, and things issues that both parties may not necessarily want to touch back on. So if the issue doesn't conciliate, we continue forward the investigation, and we get into the investigation and we believe that we can make some sort of conclusion to whether or not a violation of the law occurred, and then we make a determination of cause. So again, based on the facts and the evidence discovered in the investigation, and then either it'll be one of two things. So either we believe it's reasonable cause, which means that, again, a violation of the law occurred based on the evidence we believe a violation of the law occurred. And then if that's the case, then we issue a charge. And what a charge is a short and plain statement of fact, which the department is basing the reasonable cause finding on. So basically it's just a short, brief statement explaining we believe this occurred, and that is a violation of the North Dakota Human Rights Act, or the Housing Discrimination Act, as well as the Fair Housing Act. And it could be just on the state level, or it could be the state and federal. So for example, if it was related to age, which is a state-only protection, it would only be filed on the state level. So the charge would be only issued stating that the violation of the state law occurred. The other way it could go is that we find no reasonable cause, which means that we, based on all the facts and the evidence, we do not believe a violation of the law occurred, and then we dismiss the complaint. So these conclusions, we do have a determination or basically a final investigative report that explains exactly how we came to that conclusion. We look at issues very similar to the way a court system would. And when we do that, we use what we call prima facie. And basically what those are, they're just steps that case has to make it through. And then if it makes it through all of those steps, then it goes kind of deeper into it as to whether or not a violation of the law occurred based on more of the explanation side of things. So for example, one of the items of one of the issues of prima facie is always whether or not the person is in a protected category. So whether or not the person, let's say, has a disability. So we would look at that, and then it would again provide that report would provide the explanation of exactly how we came to the conclusions. Do we have any questions yet?
Not as of right now.
Okay, perfect. So we will go into a little bit of the common issues. We did touch base, obviously, on a lot of what is filed as complaints within the department. And one of those main ones, again, 43 of those 58 claims, or at least 43 in 43 situations, disability was addressed. So when we look at a disability, we look at whether or not an individual is with a disability under the law. So when we look at that, they have to be one of these three categories. They have to either be an individual with a physical or mental impairment that substantially limits a major life activity, has a record or history of such impairment, regarded as an individual with such impairment. So when we look at that, that first one, pretty self-explanatory. Let's say they have, something like diabetes, which it substantially impacts their endocrine system. And so that's a major bodily function. So it can be substantially limiting as a major life activity. Same, let's say the individual is unable to walk. Well, obviously that's substantially limiting them in the major life activity of walking. So they may be considered a person with a disability. The second one, with the record or history of such impairment, that doesn't necessarily mean it's currently impacting them, but it can still be something that the respondent is basically basing their judgments on, or they're basing their decisions on, what their thoughts are of that disability. So for example, the diabetes, maybe they currently aren't having any issues with diabetes, they're not having anything going on with it, but the respondent believes that they do, and they think that that's something basically is wrong with them, or that they are going to be impacted in some way. They're not going to be able to make it to work, so they're not going to be able to pay their rent, things like that. They might not necessarily currently have the disability, or it's not currently active, but they have a record of having it. And then the last one is basically to eliminate or prevent discrimination based on stereotypes. So this one might be the respondent believes the individual has bipolar disorder and the individual doesn't. They say, no, I've never had it, I've never been diagnosed with it, but the respondent is taking some sort of action because they believe the individual has bipolar disorder. That would be an example of the regarded as. So basically it's to prevent any sort of stereotypes related to a disability that the individual may or may not have. So when it comes to asking for documentation, we get this question a lot of, can a landlord ask for documentation? The short answer is maybe. In some situations they can. Basically, when it's a request for something like a reasonable modification, they can request some disability related information as long as it's necessary to verify that the person meets the Act's definition of disability. Two, that they describe the need for modification or the needed modification. And then three, shows the relationship between the person's disability and the request. So basically, if it's a lot of times when you look at the guidance, if it's something that's obvious that they're requesting, for example, a ramp, and you clearly see that they have double amputated legs, generally speaking, the request for a ramp is likely going to be pretty tied to their disability, and it may be a violation if you request additional documentation from them. If it's not readily apparent, you may be allowed to ask for documentation. It's just really dependent. One thing about the documentation as well that we see oftentimes with issues with is the individual receives the medical documentation, the respondent receives that medical documentation, and they don't think that they don't believe it, or they state that they don't think that it's very valid. That is, if they have medical documentation that proves the individual's disability, connection between the disability and that request, that really is what the law states can be done. you shouldn't act as a doctor in those situations and try to make the call yourself. You know, it certainly can be something potentially you may be able to request additional information, but you want to be very cautious with that, and potentially seek the advice of any sort of attorney if you think that you should have more documentation, because again, it can become a very slippery slope, because really the definition of the law is very clear that it states as long as you have that clear delineation between the request and the disability, that's really all you can ask for. So the reasonable accommodations and modifications. Accommodations are the alteration or change to a rule, policy, practice, or service. Generally speaking, those are paid by the landlord. And then a modification, that relates to the removal of some sort of physical barrier. Oftentimes these are paid by the tenant in private situations, or they can be paid by the landlord, depending on federally supported programs the landlord might be covered under. So those are just kind of a brief overview of the reasonable accommodations and modifications. Next week, we will have actually another session about reasonable accommodations and modifications. So we'll go a little bit more in depth. But I did want to touch on, because it always is very much a hot topic in landlord situations, service animals and assistance animals. Basically, individuals who are disabled may require the use of a service or an assistance animal in the form usually of a reasonable accommodation, maybe to request a modification to, for example, the no pets policy. So if it's a building that does not allow pets, and they make some sort of reasonable accommodation request related to their disability for their service animal, then it can fall under this reasonable accommodation request. To deny the accommodation, the landlord must prove that such an accommodation is not reasonable, not necessary, or causes an undue burden to the landlord. Basically, when we look at a service animal or assistance animal, they are not considered pets. So it would be similar, they're assistive devices basically under the law. And so it would be like an individual asking for an accommodation for a wheelchair. Generally speaking, if you deny that request, you would have to show the reasoning for it, the reason whether or not you believe that it was not reasonable, not necessary, or caused some sort of undue hardship. So specifically, we would be looking at those areas. And it can, again, hate to use the term slippery slope, but it can become that because sometimes a respondent may just be making the assumption that some sort of damage is going to happen. It can't be made on speculation. Really, it has to have true facts behind the reason or why you believe it's not reasonable in this situation, why it's not necessary, or why it causes an undue burden on it. When we look at that, you're really going to want to look at it on a case-by-case basis as well. So not just using a blanket, well, the last time we had an assistance animal, this is what we did. Really, you want to look at it on a case-by-case basis. And according to the joint statement issued by HUD in the Department of Justice in 2004, basically it states that housing providers may not require persons with disability to pay extra fees or deposits as a condition of receiving a reasonable accommodation. And that can be specific to requiring some sort of additional fee for like basically an animal fee or a pet fee in the case of any sort of damage. You wouldn't require an individual who has a wheelchair that you have concerns that they might wreck the carpet, necessarily charge them additional fee. That's kind of how HUD would look at this situation as well. HUD does have a number of documents available online, specifically for reasonable accommodations and modifications. Sometimes the verbiage is a little over the top. It's very wordy and it's not exactly the most thrilling thing to read through. But when some of the fact sheets and their questions and answers, their joint statements, and their guidance, they actually do have a number of documents out there that are actually quite helpful. And they provide it in very clear question and answer form, and it's pretty easy to go through and just give you a better idea of some of the regulations regarding specifically reasonable accommodations and modifications. But they do have a notice specifically service animals and assistance animals out there. And then also we use those documents as guidance in some of our cases. So one question we've received before with regards to, for seating disabilities. So if you have a disability with somebody who has allergies and the other tenant next door has a service animal, how do you handle those? The best advice we can give you is handle it on a case-by-case basis. You're going to have to look at what accommodations you can provide that may accommodate both disabilities. And so you're going to have to basically look at each individual disability and consider it kind of as competing disabilities of how you can accommodate each one of them. And if you're unable to do so, how you can handle basically going forward. And again, this is a great situation where if you aren't really sure what to do with it, definitely asking for some guidance is probably the best bet. I'll kind of just briefly go over the last pieces here before we finish up and have any questions. With retaliation, that is one thing we see a lot of with regards to reasonable accommodation requests as well. And basically that any sort of action of harming someone because they harmed oneself. So if an individual has somebody who files against them and they think that it was malicious or they want to defend themselves, they may act in a retaliatory fashion, and that may be a violation of the law. So employers, any sort of landlord, any of your management, anything, they really want to be very careful as far as making sure that you really are being mindful of any sort of request and making sure that retaliation doesn't happen after the fact. When we look at discrimination in publications, that's another thing to make sure you watch for and are careful of. Basically, written statements, verbal and nonverbal statements, you really want to be mindful of how things are worded. We look at the reasonable person standard. Basically, when we're looking at how something's worded, if we believe that it's, or how something can be interpreted, we're looking at based on a reasonable person standard, whether an ordinary reader or listener would think that the preference or some sort of discriminatory intent is apparent. So the biggest rule of thumb here, a lot of times this plays into advertisements specifically. Just make sure you're explaining what the property itself is and describing the property, describing the kind of tenants that you want in that property. A lot of times statements can be well-intentioned, but they don't necessarily mean that they're legal. So always making sure that really your managers are very well trained on how to deal with something if a tenant calls or has questions, either making sure that they're directing them to the right person, or if they themselves are handling it, make sure that they're very careful and mindful to how they're wording things and how they're stating things. What can you guys do to get a little bit on these things? Again, get educated, try to read up. Attending things like this are terrific ways to understand the laws a little bit better. You can always visit our website. Like I said, HUD actually has quite a bit of guidance as well that's pretty user-friendly. And then visit with an attorney that's knowledgeable in fair housing laws specifically. You know, don't go to an attorney who's great in getting you out of parking tickets but has never handled a housing case. You're going to want somebody who specifically does handle fair housing, or at least has a great knowledge of what the laws are. And then lastly, the department recommendations. Biggest thing, document everything. Make sure that you have great documentation. In a day and age where everything can easily be documented, you have text messages, emails, everything that really can clearly show when things occurred, how they occurred, how it was worded. Utilize those to your advantage. Make sure you do have good documentation. Avoid sudden and rash decisions. So he calls you up and says, I want to have 10 service animals, your instant reaction might be no, absolutely not. But stop, pause, think about it, and kind of go through, yep, we have a reasonable accommodation process for that, that we have to take in order to evaluate that. Just to kind of think again, train your managers and staff. If you have anybody who's dealing directly with the public, you're going to want them to at least understand and know, generally speaking, what the laws are, or know where to direct the individual so that they are being directed to somebody who will best be able to handle the situation and hopefully handle it with a non-discriminatory way of going about it. Again, know the law. If you don't know, or if you have concerns about it, contact an attorney. We always get calls, and I struggle giving all the time that we can't help them, but speaking, when it comes to requests for answers, we can't give very situational. I mean, it's a case-by-case basis. Without doing an investigation, we can't necessarily contact an attorney. Going to be getting you. And then lastly, we don't oftentimes have people that come to our department that explain a wonderful situation they were in, how much they loved living in the facility that they were, and they had a wonderful landlord, but they just think that they might need to a lot of times working with individuals and tenants will go a long way. And being very clear with your policies are, being practices, it will clear up a lot of questions and concerns. You still might have claims filed against you, but again, you kind of will go into the complaint with a little more knowledge that this is how you consistently always handle it. You know, you contacted it to do the right thing. You really have kind of dotted your I's and crossed your T's to make sure you're doing the right thing. So with that, is there any other questions?
We have a couple. Does a cancer diagnosis that is currently in remission meet the definition of disability by the ADA?
It can. Actually, ironically, it does under the federal law, but not necessarily always under the state law, depending on kind of what that current status of it is, because the state law does take into account mitigating factors, whereas the federal law does not.
And then if somebody is living in an accessible unit and somebody with a disability applies, does that landlord have to move the first person out so it's not discrimination?
Again, I can't necessarily give a yes or no answer in that one, but I can say you would want to follow your reasonable accommodation steps. And so if first individual doesn't have any sort of reasonable accommodation, you either, the individual that does need the reasonable accommodation, you're going to have to try to find the best situation you can, and that might be, you know, making a unit available that they can, or it could be making some sort of modifications or changes to a different unit. So if it is a floor, but you state, you know, will provide an elevator or some accommodation that's going to reduce sort of issues for that individual, you know, that always could be a solution for it too, but you're going to really have to look at the specific request and what you can do, because again, what we would be looking at is if you cannot provide that reasonable accommodation, you'd have to prove that it is some sort of undue hardship or you were unable to provide accommodation because it wasn't reasonable or whatever the case may be. So you'd really have to accommodate it, whatever way that is. And it doesn't have to be the requested accommodation always. It has to be effective, but generally speaking, you may have to work with potentially both parties to try to resolve that issue.
Could you give an example of undue hardship that has been upheld?
I don't know any just off the top of my head, but an example would be, let's say let's say the individual was asking for an elevator, and there were 0 ground floor apartments. All of them were above ground. They were all, you know, second story. There's maybe a garage or something on the first floor, and there's no elevator. And all it is a super small apartment building that has one building. It's not like a large management company, and they actually only make, let's say $100,000 a year total in all of their rents, everything like that. They financially went and looked at how much an elevator would cost and how much that would impact their financials, things like that. And they just financially, they could not afford the accommodation. That might be an example of it. I know that's a kind of a bad example, but that's the best one I can think of what an undue hardship might be, that financially it was absolutely not reasonable. There was no way that it could be done, or that it altered their entire business. So their business obviously was to renting individuals providing this accommodation. They wouldn't even be able to rent any of their apartments out. That fundamentally changes their business. That could be potentially one.
That appears to be the end of them.
Well, if you guys do have any further questions, you guys can feel free to reach out to me. I will certainly answer. I know I do have at least 2 questions out there with regards to the sexual orientation as well as the mobile home part question. So I certainly will, if you guys can reach out to me with your emails, I can provide you guys some answers once I get them.
All right, and for those attending, if you need a participation certificate, email Marilyn and let her know. Otherwise, I think we will wrap it up for today, and next week, Kirsten will also be back with modifications and accommodations. So everybody have a good rest of the afternoon.
Thanks, guys.
Thanks, Kirsten.
Thank you.
Kirsten, did everything seem to work okay for you?
Sure did.
Okay, yeah, it was a really great presentation, so I appreciate everything that you've done for us.
Yes, thank you. And I will see you guys next week. I assume we don't necessarily have to do a test run next week, but if you guys want to for any reason, just reach out.
Okay. Yep.
All right.
We'll just be in touch, but probably 10 after 1 again or so.
Yep.
Okay.
For me.
Sounds great. Okay. Thank you.
Thanks. Bye.